And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Help, I need somebody. Help, not just anybody. Help, you know I need someone.
Well, good morning and welcome to The Law Show here on CL 650 with a little help music that both of our guests this morning in studio very much appreciated, since they are very much in the business of helping people. On The Law Show today, we're going to focus on estate law and estate planning and the importance of an up-to-date will. And with us in studio are those two helpers, John Lakes and John White, partners both at Lakes White LLP, a North Vancouver law firm with the estate planning and estate litigation categories dominating. Gentlemen, welcome, John and John. Nice to have you on The Law Show.
Well, thank you, Sterling.
Thank you.
All right. So first and foremost, tell us a little bit about the firm, about Lakes White. Both of you are North Shore guys, so here you are with a firm on the North Shore. John White from West Vancouver.
That's right.
And John Lakes from North Vancouver.
That's correct.
Okay, so John Lakes, as the senior member of the firm, tell us a little bit about yourself, North Vancouver guy who ends up practicing in his own backyard.
Well, I grew up in North Van, went to Highlands, Balmoral, Delbrook. My first paid job was Oasis Car Wash, so I've only moved 2.5 blocks from my first job. Got my BA in geography, did my law degree in UBC. My father was a lawyer, so I was sort of following the family tradition. Left town and went to Prince Rupert for a couple of years, was downtown, and then returned to North Vancouver in 1981, and I formed my own firm in 1986, and through various changes over the years, it's been Lakes White since 1999, and I'm a solicitor, so I don't really go to court.
Okay.
And I deal with middle class, regular people who I can identify as well, and growing up in North Van, my past is always coming back. So
what sort of law did your dad practice, John?
He did a lot of mining law and assessment work, property assessment work. He was quite specialized. He was in the Rogers Building, which was sort of a legendary building, and he was there for many years. And he died in 2003, but he was still practicing when he died.
And
so.
what was it about estate planning and wills that drew you to this area of the practice of law?
Well, you listen to people's stories, and you try to. I mean, I don't just do that, but it's very much part of what people should be doing, even if they've got businesses or they're involved in buying real estate or cottages or whatever. It's things that they need to do, and it's just part of it's like a four-legged table, and you got to have that fourth leg, because what happens, because we're all eventually going out, whether we want to admit it or not. So just part of the process, and you hear stories which are interesting, because every family is unique, every person's unique, and just try to assist them in creating a plan which makes it easier for them to exit life. And when you do a will, it's called the last will and testament, because it's your last message to the world, because it's usually not read or not effective until after you've already died. So
interesting stuff. John White from West Vancouver.
From West Vancouver.
Went to school at U of T.
That's correct.
And what took you to Ontario?
Well, it was a desire to live somewhere other than Vancouver for a couple of years.
Not a bad idea.
I think everybody should try and do that, but then people should try and move back.
When you come back, doesn't it make you appreciate home even that much more?
Oh, yes.
All right. Now, we just heard that Lakes White, you and John have been practicing now for, about 12 years?
It's more than that. I guess we've been together for almost 16 years at this point.
All right. And again, this is such a different area of law and legal activity. I'm always curious what causes one to, and you're sitting there in law school at the University of Toronto, in your case, going, my gosh, the whole profession is, I can go do anything. And you ended up choosing wills and estates. Again, why, John?
Well, it's because I think our community needs people who practice in this area. I practiced downtown doing something completely different for 7 years, a lot of insurance defense type cases, and some personal injury cases, some commercial cases. I moved back to the North Shore in 1999 because I was looking for something different. I found quickly that one of the things that our community needs is people who practice in this area, both on the solicitor side and in what I do, which is the litigation side. I do lots of other sorts of litigation as well. I do a lot of commercial litigation. I do personal injury cases. I spent many years prosecuting federal drug offenses, but I keep coming back to wills and estates cases because there's a need for them.
Right. Now, here are two legal terms, and John Lakes, you open the door by describing yourself as a solicitor, a lawyer who does not go to court. A barrister, John White, is what you are because you do go to court, right?
That's right. That's right. I've been called worse things than that.
I
but,
would well imagine you have, but then you see some lawyers and you see their ads, they'll put barrister and solicitor under their name.
And we are. I can go to court as well. I don't go very often. I usually do uncontested chambers matters.
Okay.
But the laws got so complex from the old days where you could be everything. You can't be everything anymore.
Right.
And so you have a certain inclination, and some people like arguing matters before judges and some don't, and I don't particularly like to do that.
But that's the dynamic of the partnership with the one who really enjoys that and you who take care of the other end of the activities.
And I mean, in this area too, you're dealing with real people. I mean, the thing is, the advantage of law is when you graduate from law school, you're given a box of chocolates. And some people know exactly what they want to do, and some people don't. And, I just chose that I always wanted to deal with people.
Right.
As opposed to you can be a big downtown law firm where people like that, where they spend all their time looking at documents, but they never actually get to meet a person who's a client. So John and I are running a business. We're dealing with people, and it's something I enjoy. And I've been doing this for a long time. And I haven't lost my interest, because every time you think you've heard the last story, another story comes in.
Sure. And as the song said at the beginning of the program, John, it's help. And there you are, both in a position to help people. Can we go right to, and I'm going to try your patience already, gentlemen. I have it. I feel it coming on. But this is really important. If we're going to sit down and have a good discussion about the type of work you do in estate planning and wills and litigation and all of that sort of thing, take me back to square one, please. What is a will, and why is it so important?
Well, a will is a written document that basically tells the people after you're gone how you want your assets to be dealt with. Now, there's other documents that you can do besides a will. First of all, you can have a joint asset. So if you have a house that you own jointly with your wife,
right,
upon your death, she just files a death certificate and goes directly to her. You can have things like life insurance policies
with a beneficiary.
With beneficiaries.
Sure.
So those are outside of wills. But if you don't have a will, then it's called administration, and the government will direct how your assets go, which is not how people always want.
Right.
So under the Administration Act, if you pass away without a will, then your assets, first of all, if you've only had one wife, the first $300,000 goes to your wife, and then it goes one half to your wife and one half to your children. If you've in your second or more wives, then the first 150 go to your wife, and then the rest is half goes to the wife and the half goes to the children.
So it sounds already that the more complex a life you've led, John Lakes, the more imperative it is that you resolve at the end of your life with some kind of will, some kind of statement of direction here.
Well, you have, particularly depending on the nature of your life. So, for example, if you have children under the age of 19 and you don't have a will, their money goes to Public Guardian Trustee, which is a bureaucratic organization. They do a good job, but they charge a fee for it. And all of a sudden, these kids could get a big check on their 19th birthday, and you may not like that to happen.
Okay.
You might have somebody with a mental health disability, and if you don't have a will, again, the money goes to Public Guardian Trustee. And then if you both die at the same time, if you die within 5 days of each other, there's a presumption that you predeceased the others.
Right.
So administration's there, and for a lot of people, it's not really how they want things to be done.
John White, how many of us have wills versus those of us who don't and are, well, maybe working on it?
Well, I can't point you to any statistics, but we do talk about the 40-40-20 rule from time to time.
And what's that?
With 40% of the population not having a will at all, another 40% of the population having an old will that they put together years and years ago when their lives were different.
Right.
And 20% having a more recent will that reflects the reality today.
So really then, on any given day, anywhere in Canada, only 20% of the folks in that town are likely to have a valid, effective will? Can I jump to that conclusion?
That'd be a reasonable estimate.
Holy smokes, that's kind of weird, isn't it? So the 40%, I suppose, let me just run this by you as a good example, because I can remember in my life when I was about 30, and children started to arrive. My daughter, the first child, arrived, and she changed my life, I'll tell you, big time. I got life insurance. I made a will. We bought a house. And, I mean, all of a sudden, the ducks started to line up, and life became terribly organized. And I must say that since those days of really understanding the need to have a will and to be that organized, things have, kind of got a little relaxed ever since. And I don't even know, to be perfectly honest with you, where my will is. I know it's on file with a lawyer somewhere downtown Vancouver, but that's about as close as I could get to identifying its location. And John Lakes, that's not a very smart position for me to be in at all, is it?
No, because sometimes if you can't find your will, you don't know where it is. And one of the things that happened when my father was in the Rogers building, it was a building that lawyers would come and go. And lawyers used to keep original wills with the idea that you get probate or whatever. But you'd lose track of it. My father would have all these people leave wills, and they're perfectly valid wills. Some of them were back even from the 30s or the 40s, and they're just sitting there.
Right.
And nobody ever claims them, and nobody ever picks them up. So there's no point having a will if you can't find it, for starters.
Right.
And so, I mean, not many lawyers keep wills anymore. Sometimes they do, but usually if you're going to have a will, it's important people know where it is. Mm-hmm. Mm-hmm. And you can, when you do a will, you can file a notice to Victoria. But, I mean, that is really an issue, and that people don't know where the wills are.
That's a good point, because to be perfectly honest with you, if you ask me to identify the exact location of my will in 30 seconds or less, I strike out. I don't know. John White, this is a word that your partner here has used a couple of times already, and doubtless will be used dozens of times in the weeks and days ahead. What does probate mean?
Well, probate is the process through which a will is accepted legally by the courts. Probate and the word proof share similar roots. When you apply for probate, you're making an application to the court to prove the will, that is, to have the court accept legally the will that you are trying to prove. Normally that's a paper process in that you submit a number of documents to the probate registry of our Supreme Court.
Okay.
The probate registry, or the people at the probate registry, will review these documents, and if they're in order, they will issue a grant of probate.
That means the will then can be executed. The people who are supposed to receive money can get their money.
And it puts the executor named in the will into the driver's seat.
Okay.
And allows that person to get on with the business of administering the will. But sometimes wills are contested for various reasons.
Sure.
And sometimes it becomes necessary for the executor named in the will to start a lawsuit before the court to prove the will in what we call solemn form. Some of those cases go to trial.
Yeah.
And the judge will hear evidence as to whether the will is valid, whether it's not valid. They get challenged for all sorts of reasons.
So, John Lakes, I go to this law firm where I think my will is, and they say, well, haven't seen you for 25 years. Well, I'm here to collect my will. Well, we threw it out. You hadn't been around for 20 years or whatever. We threw it out with a whole whack of documents. So then what?
Well, first of all, law firms not supposed to throw them away.
Okay.
And if they, they're supposed to keep them forever, or else if you decide to retire, you can get delivered to the Law Society. But 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 if for some reason they did throw it away, you better do a new will.
Okay, so and even if I haven't done a will, even if I know my will's in the drawer of my desk in the den, but that's the will I made up when my daughter was born in 1980. Chances are, lo these many years later, it's really not terribly applicable to my current circumstances. How do I upgrade that?
Well, you can do a new will, and one of the most important things is when you do a new will, one of the very first lines is you revoke all previous wills.
Oh, so you automatically cancel everything else out
when you do a new will. So you don't have like will number 1 or will number 2 or like a quiz show. You just want to have one will. You want to have things as simple as possible.
But I'm catching from the expression of your partner, the guy who goes to court, that it's not necessarily always that cut and dried or that clean, and that's where some of the contesting and the fighting begins, John.
Well, we do often see cases where there are disputes over any number of aspects of, we'll call it the new will.
Right.
For example, a disappointed beneficiary who may have stood to inherit under the old will and is now being cut out of the new will.
Or certainly greatly reduced. Right.
Might question whether the will maker really knew what he or she was doing at the time that they executed the will. They might look at issues such as, was the will properly executed?
Sure, right.
They might look at questions as to whether the will maker was under somebody's thumb when they made the will.
Undue influence?
Undue influence,
right.
As we call it.
Right.
And those are just issues dealing with whether the will is valid or not. That's the sort of thing that we talk about in these probate actions, these lawsuits that I was talking about a moment ago, where we put these wills before the court and ask them to prove them in solemn form. Or if you're acting for the disappointed beneficiary, maybe you're asking the court not to approve them in solemn form, but to throw them out.
Interesting stuff. We need to take a break here, and we've just begun. Our guests in studio on this episode of The Law Show, John Lakes and John White. The firm is Lakes White LLP of North Vancouver. They are estate planners and estate lawyers, and we'll continue with lots more on wills after this quick timeout on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.